The petition for mental health treatment. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO form PCM 201. SCAO for State Court Administrative Office, PCM for Probate Court, M for Mental Health Division, 201, that's the form number. Now, with all of these forms, you're welcome to contact our office. We'd be happy to provide them free of charge. This form is used when somebody is experiencing a mental health issue such that they need a hospitalization for their treatment. Now, we understand that dealing with a mental health issue within your family or within your community is one of the most stressful things to deal with. So hopefully this form will give you some of the basics on how to navigate through this often confusing and complicated process. The idea concept-wise of Michigan's mental health process relating to court intervention and an involuntary hospitalization is when there are acute situations going on such that a person is a threat to themselves or others, you can use this process to get an involuntary hospitalization of that individual. So let's work our way through this process. The forms, like all of these SCAO forms, are guided by various statutes and court rules. And as you can see from the floating arrow, the Mental Health Division, which is MCL 330 and the following from there, 1100, and as well as the statutes that are referenced there, there's quite a few of them. And the Mental Health Division of the Probate Code and the Mental Health Code is complicated, as well as the court rules involved here. So really understanding the interplay of these various statutes and court rules is really going to be helpful for you to go through this process. So we urge you to work with a skilled, competent probate lawyer to understand the statutes and how to navigate through the process itself. You can see there's quite a few statutes and court rules there. So get familiar with them to understand how to navigate through this particular process. But let's walk our way through this form. This is the initial form used when you are trying to take an individual who has, under the statutory definition, mental illness, and you're trying to get hospitalization for them. So here in the top left corner, you're identifying the county, and in the top right corner, it says the file number. But in this particular case, there may not be a file number assigned yet because it may get assigned at the initial filing. You can see in the red rectangle, it says a petition for mental health treatment and whether this is an amended petition or the original petition. From there, some basic information is included here. In the matter of is the name of the individual upon which you're seeking the intervention, the last 4 digits of their social security number, and then there's this little space here for their date of birth, place of birth, race, and sex. Below that, you identify your relationship, the petitioner's information, and you would print your name there. And you identify your relationship to that individual. Now, a relationship can mean a lot of different things. It can mean you're the mother or the father, the son. It could mean you're a social worker, a neighbor that is observing and witnessing behavior, a peace officer, etc. So the definition of who can be the petitioner is quite broad here. And it allows for that person to bring forth evidence, both personal direct evidence that they've seen, as well as information that they've also gathered. And you can identify here that you believe that that individual is in need of treatment. So let's understand that if an individual voluntarily submits themselves to mental health treatment or hospitalization, this isn't the process. This is when they won't cooperate and they don't recognize their need for treatment. So here you're identifying that you believe the person is in need of treatment. Number 2, identify some basic information about the date of birth, as well as their address and residence. And this can be confusing because we know that some people with mental health issues are moving around. They may be couch surfing, they may be on the streets, they may be in a hotel or living in their car. So this address issue can be a little confusing, but it's asking for a permanent residence rather than a transient location. So again, that's why they use the word permanent residence here. It identifies where they presently can be found. Now, there's another checkbox box here that says the petition is for a person who was found not guilty by reason of insanity. This would relate to a criminal proceeding. Number 3 is really the essence of this particular petition, the basis for when you're seeking the court's intervention. Let's go through each one, and I'm going to read them because each one kind of gives a little bit of context of how you're asking the court based on your belief, what you're observing, and what you believe. It says, I believe that the individual has mental illness and, the first checkbox, A, as a result of that mental illness, the individual can reasonably expected within the near future to intentionally or unintentionally seriously physically injure self or others and is engaged in acts or made significant threats that are substantially supportive of this expectation. So again, suicide ideations, threats to others, threats of withdrawing treatment for themselves or food, things like this could be a basis here. Section B, as a result of that mental illness, the individual is unable to attend to those basic physical needs that must be attended to in order to avoid serious harm in the near future, and has demonstrated the inability by failing to attend to those basic physical needs. So again, this mental illness is causing them to not attend to their basic needs. C, the individual's judgment is so impaired by that mental illness and whose lack of understanding of the need for treatment, again, a lack of recognition of their own need for treatment here, has caused him or her to demonstrate an unwillingness to voluntarily participate or to adhere to treatment that is necessary on the basis of competent clinical opinion to prevent a relapse. So again, this idea that they don't recognize their own need for treatment at this time, and you're asking the court, because of their lack of recognition, to voluntarily place themselves into treatment, you're asking the court to intervene. Now, the conclusions that are set forth in 3 are now provided additional space for supportive information. Now, Section A speaks of the personal information, your personal observation of that person doing certain acts. So here, there are 2 lines here, but of course, you can attach as much supportive information as necessary. It may include letters, text messages, voicemails, things like that, to provide additional support. But this is personal observations of the petitioner. B speaks about not their own personal observations, but following conduct or statements that others have seen or heard. So for example, if you've been reported information, that information can go there. And then there's a witness section here. Let's move to the back side of this petition. The back side identifies the interested persons in the proceedings. And again, the term interested persons are defined by statute and court rule. So again, you're seeing a space for the spouse and guardian. At a minimum, those are identifiable names that need to be included on this petition for purposes of service. And then it says, specify the county where the guardianship was established. So if there's a guardianship in place, identify the court upon which that guardianship has jurisdiction. Again, Section 6, identifying if the person is a veteran or not. Section 7 is if there's any clinician certificates, physician certificates by a licensed psychologist within the last 72 hours, or psychiatrist, or no clinical certificate because they've had outpatient treatment. It has been requested. So again, a space to identify if you're attaching any medical reports. Now 8, it says for hospitalization and combined treatment, an examination cannot be secured. So that's for the hospitalization piece. The request is, what are you asking of the court? You're requesting that the individual be examined at, and often there is like a triage place in a particular community in which the initial assessment is done, or a hospital for mental health treatment. And you're asking for a peace officer to take the individual into protective custody. So maybe an EMS transport of that individual to the hospitalization. Number 9, I request the court to determine the individual to be a person requiring treatment and to order. You're asking for hospitalization, maybe hospitalization as well as outpatient treatment, or assisted outpatient treatment without hospitalization. So again, some variables here to choose. 10, I request the individual be hospitalized pending a hearing. And this is very typical to be included because you're asking for the hospitalization during that window of time upon which the individual gets to be assessed and they get to determine whether they want to object or defer. There's a deferral process to the recommendation or evaluation that has been provided by the medical provider. Now here, as with all of these scale forms, there's a penalty of perjury clause. So be really careful about examining the information because you're stating that you've examined it and it's true to the best of your information, knowledge, and belief. A place for the signature, as well as the address of you, the petitioner, and then on the left side if there's an attorney involved. The bottom section is really for the hospital only. You don't have to worry about that. So this particular petition, when completed, as well as the accompanying documents, gets brought to the mental health division of the probate court. It's filed there, and at the counter, they will make sure that all of the requisite information is provided. And then you'll have a hearing quite quickly in front of a judge to be able to put forth the basis for this involuntary hospitalization. And then after the hearing, if the court determines that the person is requiring, or if the order is going to be granted, there's an order that gets granted here, and that order then goes for that transport to the medical provider. There's a whole array of various statutes that relate to an individual's right to object and to have a trial, a jury trial, as well as to call witnesses, as relates to these involuntary hospitalizations. So a lot of interesting pieces here, as well as what the court is authorized to do. Unfortunately, the mental health process is about kind of stabilizing and reacquainting them back into the community once they're stabilized. So we talk about this revolving door process. You involuntarily hospitalized, they stabilize, they may come back out to the community, and then the mental health may deteriorate, and you may have to do this over and over again. It's a really frustrating process, but also a really helpful process for those who are in a position where they're in need of treatment because of mental illness that isn't otherwise being recognized, and that they're an imminent threat to themselves or others. At the Probate Pro, we're passionate about everything probate. If you have a question about this particular form or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.